Hello there, I'm attorney Kelly Longtin. And for all you 90210 fans, I want to talk to you today about Shannen Doherty. We know that she has recently passed, but she understood with divorce that timing is everything when it comes to estate planning. According to a Centers for Disease Control and Prevention survey, there are more than 670,000 divorces and more than 2 million marriages in 2022. Now, divorce is a common life event that many Americans face during their lifetime. Some states have laws that automatically end an ex-spouse's appointment as decision maker in their spouse's estate plan with the ending of the marriage, as well as their right to any inheritance to which they may have been entitled. However, what happens if you die after you file for divorce, but before it becomes final? Shannen Doherty faced the same question. In her case, the divorce was deemed to be finalized before her death. Now, Shannen was born on April 12, 1971, in Memphis, Tennessee. Shannen is most known for her iconic roles as Jenny Wilder in The Little House on the Prairie, Brenda Walsh in Beverly Hills 90210, and Pure Halliwell in Charmed. After battling stage 4 cancer for more than 4 years, she passed away on July 13th of 2024. Surviving her are her mother, with whom she was very, very close, and her brother, Sean. While Doherty was battling cancer, she was also in the midst of a divorce from her third husband, Kurt Ismarenko. The divorce proceedings took more than 15 months to conclude, with Doherty filing for an uncontested divorce and signing the necessary paperwork the day before she passed. Ismarenko signed the documents on July 13th of 2024. A family law judge signed off on the divorce 2 days after Doherty had passed away. According to a stipulated agreement with Ismarenko, Doherty's estate was able to retain the couple's home in Malibu, California, a Salvador Dali painting, several cars, and all earnings from her acting. In addition, as part of the divorce proceedings, she had filed an income and expense declaration stating that she had $251,000 in the bank, another $1.8 million in stocks and bonds, and insurance money from a lawsuit over damage done to her California home. She also stated that she had real property worth about $3 million and about $134,000 in a pension fund. In an interview with E! News, Doherty discussed how she had started to sell some of her valuables, and with that money, was able to take trips with her loved ones to create memories. She also acknowledged that in selling property and other items, her priority was to make things as easy as possible for her mom. With both parties finalizing the divorce and signing their respective waivers, Doherty was able to control what would happen to her money and her property when she passed away. Had she passed away before the divorce was recognized as final, things could have looked much, much different. Because a marriage is a legal relationship while you're alive. The passing of one spouse ends the marriage, leaving the other party as the surviving spouse. Although she and Ismarenko were in the middle of divorce proceedings, Doherty could probably not change the provisions in her estate plan that dictated who would receive her money and property until the divorce became final. Therefore, any money or property that she would have left her soon to be former spouse under a will, trust, or beneficiary designation would probably still go to him. If he was not included in her will or trust, he may have been able to file a claim against her estate for his elective share, and that's just a statutory minimum that a surviving spouse receives under state law. Had there been no will or trust, California's intestacy statute, meaning the state's plan for what happens to a person's money and property if they die without a will or a trust, would have dictated what Ismarenko was entitled to. According to the statute, his inheritance would have been her half of the community property, her half of quasi-community property, and half of her separate property. Although he would have ended up with all of the community property and quasi-community property, he would have had to share Doherty's separate property with her mother. present, the exact terms of Doherty's estate plan are unknown, but we do know that Doherty's mother played an important role in her life and was someone that she wanted to provide for. The lack of public information may be because Doherty utilized a trust or beneficiary designations as part of her estate plan. The benefit of both strategies is that the matter stays out of courts and the public eye. However, utilizing a trust allows for additional restrictions and instructions about how a beneficiary receives their inheritance, while naming someone as a beneficiary through beneficiary designations will usually result in the beneficiary receiving the full amount outright with no additional protections or restrictions. Now, I certainly know that going through a divorce and planning for your incapacity and death can be stressful. If you need help in navigating through that rough chapter so you can craft a protected future for yourself and your loved ones, you want to reach out to a qualified estate planning attorney that practices in the state in which you live. So please like and subscribe our page below if you want to learn more about estate planning, how it all works, and how it can benefit your family. Thank you for watching. I'm Kelly Longtin.